second for it to load up. There we go. Great. So we are now, I briefly thought I saw somebody trying to get in for a second, but I was mistaken. We are now live streaming. I will start today just by introducing myself. I am David Aero. I am the monitor for Courtroom 1. We'll begin by having each student introduce themselves. We'll have each student introduce themselves. So I'll call out each role individually. However, I know a number of you will do multiple roles. However, in this case, I want you to just come on with your camera, unmute yourself, and then introduce yourself for that specific role. And we will call you again as we hit each individual role. That's because the scorer's score sheet has a blank for each spot, and they need to fill your name in. So if you introduce yourself for multiple roles, it will be difficult for them. So we'll go through one at a time. Let me check real quick. I see Sunita join. I didn't know if you had anything that we needed to be aware of right now, or if you're just checking in. Well, then I guess that means she did not. We'll start by introducing prosecution opening. Please turn your camera on, unmute, and introduce yourself.
Good morning, Your Honor. My name is Laura Thompson, and I'll be performing the opening.
Thank you. Whoever's performing the defense opening.
That would be me, Your Honor. I will be performing the defense opening. My name is Jack Nauman.
Prosecution counsel number 1.
Sorry, my mouse seems to be frozen, but my name is Emma Klausner, and I will be the first counsel.
Okay, and I'm going to pause for a second. Ms. Phipps is joining us. Judge McCarger. As soon as I see her actually leave the waiting room to come here.
Mr. Aero, I threatened her with contempt by a text message, so that's why she's jumping aboard.
We're trying to get Kathy to source.
She should know better than to be late for my courtroom.
Well, we're so close. It says joining.
I've heard that before.
Yeah.
How's my audio, David? Am I loud? Am I quiet? How do I sound?
I can hear you. There's a tiny delay, but nothing significant.
Okay, good.
This is the host will let you in.
Hold on for a second. Let me.
We want Art to just get in.
If he can. Okay, we'll keep working on that, and we'll get Ms. Phipps' roster list if that becomes necessary. She seems to be having a computer issue getting on. So I believe we stopped with the introduction of prosecution counsel 1. Defense counsel number 1, please introduce yourself.
Sorry, did you say defense counsel one?
Correct.
Oh, sorry. My name is Jack Nauman, and I will be directing Blake Van Owen.
Thank you. Prosecution counsel number 2.
I'm sorry, I'm having some video trouble, but my name is Laura Thompson, and I'll be performing the direct examination of Kyle Kuzak.
Hurry in one more time.
Defense counsel number 2.
That would be me, Your Honor. My name is Mary Napolitano, and I will be direct examining Taylor Perkins.
Thank you. Prosecution counsel number 3.
Good morning, Your Honor. That would be me, Raven Chamberlain. I will be directing.
I think, I don't know if that went through for everybody. Did you were able to catch that? Okay. Defense counsel number 3.
That would be me, Your Honor. My name's Sophia Schumann.
Prosecution witness number 1.
Good morning, Your Honor. My name is Abby Miller, and I will be playing the role of Detective Jordan Markowitz.
Thank you. Defense witness number 1.
Good morning, Your Honor. My name is Paige Weidman, and today I am Blake Van Owen.
Prosecution witness number 2.
Good morning, Your Honor. My name is Rachel Yett, and I will be playing the role of
Defense witness number 2.
Good morning. My name is Esther Von Reich, and I'll be portraying Taylor Perkins today.
Prosecution witness number 3.
Good morning, Your Honor. My name is Shanti Grossman, and today I will be playing.
Defense witness number 3.
Hello, my name is Daniel Yanez, and I'm Avery Becker.
Thank you. Prosecution closing.
Good morning, Your Honor. That would be me, Raven Chamberlain.
Thank you. And defense counsel closing.
That would be me, Your Honor. Sophia Schumann.
And during the presentation, we may see 2 other individuals come on. They are the timekeepers. I'll ask the prosecution timekeeper to introduce themselves.
Good morning, Your Honor. I will be the prosecution timekeeper.
Thank you. And the defense timekeeper.
Good morning, Your Honor. I'm the defense timekeeper.
Thank you very much. Mr. Spiciotti, I see you joined. Thank you so much for jumping on. We are having technical difficulties with the other score. Judge McCarger, Mr. Spiciotti has been able to join. He had volunteered to be a scorer, and we happen to have an extra slot for him this morning. So he is joining as the 3rd scorer. As a reminder, I know that you've scored before, Mr. Spiciotti. For this one, we just went through the introductions. As they come up, if you want to double check who they are, obviously each one has the team name and their full name, and then a character name if they're testifying as a witness. So I won't ask them to run through it again, but just wanted to confirm that they've updated all of that. So
thank you.
Thank you. As a reminder, only the presenting attorneys, prosecution and defense, and a witness for a maximum of 3 individuals, plus the judge, should have their camera and microphone on. Everyone else, I'll ask you to keep your camera off and muted. Timekeepers may come on as necessary to alert their team at appropriate times. If you are not a performing attorney witness or timekeeper for any of the teams, please exit now. I believe we've identified everyone, and so it appears everyone's appropriately in the courtroom. But if for some reason you did not introduce yourself and you're not preparing or performing one of those roles, please exit now. Failure to do so can result in sanctions for the team. You can certainly join and watch on the YouTube live stream at this point if you would like. Mock trial is now in session, so I'll turn the courtroom over to Judge McCarter.
Thank you, Mr. Aero. My name is Ian McCarter. I'm the presiding judge today. I don't have the usual roster of introductory comments just right at my fingertips. So stand by just a second. Let me make sure. Mr. Aero, can you direct me to the, under the rules section, the recital that I need to go through, because I don't have that in front of me. I think I might be able to do it from memory, but just double checking if there's a script. But let me get started on that and see what David can do. Welcome, everyone. This is round 3. I have the prosecution as Sonic. I have the defense as Super Mario. Counsel has introduced themselves, but I may need to follow up with confirming names as we go. I am presiding here. The first thing I want to do is remind everyone that this proceeding is being recorded. And so just wanted everyone to be aware of that. I also want to make certain that if there is anyone in the courtroom who is not directly affiliated with the 2 teams I just mentioned, I ask you to step out. The competition will proceed as you might expect. I want to make sure that we swear the witnesses and swear the attorneys and other team participants. I think if you don't mind, what I would like is that everyone activate your cameras, all the team members activate your cameras, and I'll do a brief swearing in. Is that okay, David? You are muted. There you all are. Yeah.
It's not a
Make
court
sure it
appearance
works.
unless I have tried to talk while being muted. Yes, that is perfectly fine.
Okay, let's start with the attorneys. Raise your right hands and repeat and just respond in the affirmative. Do you swear that you will uphold the rules of the mock trial competition and that your presentation today will adhere to the rules and the ethical requirements of the mock trial competition? What say you? You have to say, I will, or I do, sort of like, yeah.
I will.
I will.
All right, thanks, everyone. Thanks. Let's see, let's go to the scoring jurors for a second. I should have 3 of you. Arthur, Kathy, and Bobbier. Let's activate your screens, please. Raise your right hands. Team members, you may blank your screens if you wish. There we go. All right, scoring judges, do you swear that you will score this round in accordance with the rules of the mock trial competition?
I do.
All right, thank you, everyone. So I believe that we have everyone sworn. I want to remind everyone too that any disputes will be resolved in accordance with the competition rules. So I assume that lead counsel is familiar with how those rules work if there are any disputes or protests. David, anything else that I need to cover here? I'm blanking.
No, I think we are ready to go if you want to allow them to begin opening.
Okay.
I
so
apologize
is-
unless they have any pretrial matters.
Okay, let's start with that. Thanks, David. For the prosecution, can I have lead counsel identify him or herself and indicate whether we have any preliminary matters you wish to raise?
Good morning, Your Honor. My name is Emma Klausner, and the prosecution does have a few pretrial matters. First, we would like to inquire into the court's preference on screen sharing and when to do so.
You may share your screen when offering or when inquiring about exhibits or things that you want to, demonstrative evidence you want to present. If I reject an exhibit, if I don't admit an exhibit, then I will ask you to kill the screen sharing, and I will instruct the jury to disregard what was on their screens. I think that's about the only way to do it. So whenever you refer to a writing, then I will ask you to share your screen. The scoring judges do have copies of the case materials if they need to refer to them, and we'll just handle publication as we go. Does that answer your question, Ms. Klausner?
Yes, Your Honor, thank you. We would also like to ask if redirects will be allowed in this court.
I will use my discretion. It depends on how we're doing with time. So let's just watch the clock, and the rule will be uniform as to both teams, but we'll just have to see how much time you're using.
We'd also like to ensure that every juror has a copy of stipulated facts as well as jury instructions.
So let me pause for a second and check with the jurors. The statement of stipulated facts is very brief in this case. As I recall, it's a handful of common stipulations, authenticity, and a specific reference to video, I believe. Ms. Klausner, with the consent of the defense, because these are stipulated, would you mind sharing that on your screen with us for a moment? Do you have that?
Yes, I can ask co-counsel to share that.
Let's do that and just make sure everyone sees it, and then I will deem those so stipulated. That's the way I remember it. Pretty brief. Chain of custody is not in dispute. The stipulations obviously cannot be contradicted. Exhibit 22 is a copy of a recording from a portion of court proceedings in a case against one Jonathan Rollins. For the defense, let me pause there, Ms. Klausner, and ask lead counsel for the defense, do you have any objection to publicizing the stipulated facts in this way?
No objection, Your Honor.
And that's Ms. Schuman, right?
Yes, Your Honor.
Okay, let me get caught up. Thank you. So the stipulations are deemed published to counsel and to the jury. Any other preliminary matters, Ms. Klausner?
Yes, lastly, we would like to inform the court that we are all competing from the same school. And so between the exchange of attorneys and witnesses, we'll need time to sanitize the area quickly, and we apologize for any delay.
That is acceptable, and in these times, I would expect nothing less. For the defense, Ms. Schuman, anything else you want to add to this preliminary matters?
Yes, Your Honor. First, that the timekeepers have a moment between each witness to alert the rest of the lawyers how much time they have, both on direct and cross.
That's appropriate, and I will try to remember to pause between examinations to give the scorekeepers time to get caught up too. So just I will try to remember that, although sometimes I tend to forget. Anything else, Ms. Schuman?
Yes, the defense asks to have each witness, on both counsels, be able to have an exhibit notebook or packet in front of them so as we do not have to share screens before we enter the exhibits, but as soon as they are entered, we are allowed to share the screen for the jury.
That's acceptable to me as well. You know, I will handle screen sharing, as I said a moment ago. I want to make sure that the jury has an opportunity to see those exhibits if they are not able to grab them from their own computer systems. But I also want to make certain that if I reject an exhibit, that we don't display it any longer than necessary to handle it. Ms. Schuman, anything else?
Yes, and then finally, that any video footage that is shown during this trial on either side should not be used in part of our time, and so the timekeepers would pause their clocks during the video footage.
Let me check with Ms. Klausner on that. Is there any objection to pausing the timekeepers while video is running?
No objection, Your Honor.
All right, so the timekeepers are so instructed. If there are any questions about this, we can stop and figure it out then.
Your Honor,
Anything further from the defense? Okay, thank you, Ms. Schuman, Ms. Klausner. So let me ask if the prosecution is ready to proceed to opening statements.
Yes, Your Honor, we are ready to proceed.
All right. And for the defense, is the defense ready to proceed to opening statements?
Yes, Your Honor.
All right, so let us begin with the prosecution's opening. Please identify yourself for me before you begin.
Good morning, Your Honor. My name is Laura Thompson.
Thank you, Ms. Thompson. If you're ready, you may proceed.
Are the timekeepers ready?
Yes, I'm ready. Yes, I'm ready.
Okay. So with that, Ms. Thompson, you may begin.
Good morning, Your Honor, opposing counsel, and ladies and gentlemen of the jury. Get out, get in, get even. Today you will hear the story of Mackenzie Brackman, a devoted defense attorney, somebody who helped other people that usually wouldn't get a second chance. He worked day in, day out, tirelessly to make sure his clients got the best help. With the small free time that he had, he spent that time devoted to helping a high school mock trial team. Some of the kids on his team were Alex Cifuentes, Taylor Perkins, and Avery Becker. Alex Cifuentes respected Mr. Brackman and saw how hard he worked and how much he cared about each individual on the team. Taylor Perkins never had a problem with Mr. Brackman. They saw that he still cared about the team even when times got rough. Lastly was Avery Becker. Avery Becker did not respect Mr. Brackman. They believed that as a high school student, they were a better attorney than him. So they wouldn't listen to his advice, and they would make things up on the fly instead of putting in the work that each of his friends put in. So, during one heated argument, Avery Becker had won Best Attorney and Best Closing. In front of the whole team, Mr. Brackman said that he didn't deserve it because he didn't put in the work that each of his team members put in. Avery Becker became impulsive, angry, and aggravated. So they became really angry and started yelling at Mr. Brackman. Mr. Brackman finally had enough of the disrespect, so he said, "Get out of practice and get out of my life." So Avery Becker, with their impulsive nature, grabbed a permanent marker. They went to Mr. Brackman's Porsche and wrote Worst Attorney Award. Of course, afterwards they felt horrible, but this proves that they're able to act on their impulses. On March 6, 2020, Mr. Brackman found himself home alone. An intruder matching the height and build of Avery Becker, the defendant, came into his house and stabbed him in the back. Mr. Brackman later bled out and passed away. When Mr. Brackman died, the world lost a devoted attorney, a friend, a colleague, a peer, and a coach. Today, the prosecution will call 3 witnesses to the stand. We will call Alex Cifuentes, Blake Van Owen, and Kyle Kuzak. Blake Van Owen and Kyle Kuzak will explain to you through ring videos that an intruder matching the height and build of Avery Becker got into Mr. Brackman's house. Then you'll hear from Alex Cifuentes, a friend of Avery Becker's. They'll explain to you how bad the arguments were between them and Mr. Brackman. They'll also tell you about these incriminating text messages they received not long before the death of Mr. Brackman, where Avery Becker said that they would get in to Mr. Brackman's house and that they would get even. The defense will also call 3 witnesses. They'll call Blake Van Owen, Taylor Perkins, and Avery Becker. Blake Van Owen doesn't have half as much experience as both of our experts. They couldn't make it as a cop. They couldn't make it as an SRO, so they started a private practice with their limited knowledge. They're getting paid hundreds of dollars to be here today, and they've only ever testified on the defense. Then you'll hear from Taylor Perkins. Taylor Perkins is best friends with the defendant, Avery Becker. That makes their whole testimony invalid and biased. Lastly, from the defense, you'll hear from Avery Becker. Avery Becker will try and tell you that the relationship between them and Mr. Brackman wasn't that bad. But as you'll hear from Taylor Perkins and Alex Cifuentes, they constantly argued, which caused stress not only on the 2 of them, but the team as a whole. As you listen to the prosecution's case, you'll hear 3 things to be true. Avery Becker was told to get out of practice, and get out of Mr. Brackman's life. Avery Becker got in on March 6, 2020, into Mr. Brackman's house, as shown through the ring videos, and Avery Becker got even. Today, the prosecution has the burden of proof. That means that we must prove to you beyond a reasonable doubt that Avery Becker is guilty. As you hear the prosecution's case, you'll realize that there is no burden. There is just proof that Avery Becker was told to get out of practice. Avery Becker got into Mr. Brackman's house, and Avery Becker got even. Thank you.
Thank you, Ms. Thompson, for your opening. We'll pause for just a second to let the scorers get caught up, just a few seconds. And then we will proceed to the defense opening statement. Please identify yourself for the court. You may proceed for the defense.
Good morning, Your Honor. My name is Jack Nauman.
Mr. Nauman, if you're prepared to proceed, go ahead, deliver your opening.
Okay, thank you. The easy way out. Today, the prosecution has accused Avery Becker of criminal mischief, the burglary of Mr. Brackman's home, and his murder, because Avery Becker was the easy way out. Yet, where was he at the time of the crime? The prosecution cannot prove that Avery Becker, their only suspect, was anywhere near the victim. On March 6th, Avery Becker and Taylor Perkins walked through a buzzing mall, through their favorite shops and restaurants, one of which was their favorite burger place, the Fry Shack. Taylor Perkins staring at his phone the entire time, while Avery Becker listened intently for her phone's ringtone. The phone she had lost just 1 day ago while sitting at the Fry Shack with Taylor Perkins and Alex Cifuentes. Alex Cifuentes was on the mock trial team, but he was not one of Avery Becker's closest friends. Alex Cifuentes is, in fact, testifying against Avery Becker in court today, claiming to have received texts from Avery Becker from the phone Mr. Becker did not have. However, that day at Fry Shack, the missing phone was the greatest of their worries. Little did Taylor Perkins and Avery Becker know that during their frantic search for Avery Becker's phone, Taylor Perkins' texts and calls were going to a phone, yes, Avery Becker's phone. However, it was nowhere near the Fry Shack. It was in the hands of somebody else, but nobody knows who they were. None of the other suspects were even investigated. They are living their best life anywhere that isn't this courtroom here today. Investigating 2 witnesses was way too much work for these prosecution witnesses. They were content taking the easy way out, investigating only 1 suspect, failing to investigate anybody else. It was easy for them. These witnesses, Mr. Markowitz and Mr. Kuzak, sure, they found evidence, but only evidence that supported their case. Evidence like cell tower data from just minutes before the crime occurred. But where was the cell tower analysis from the day before or the morning of? Cell tower data that could prove whether Avery Becker and Taylor Perkins were really at the mall and whether the phone went home the previous night with Alex Cifuentes or Avery Becker. But why wasn't it collected? Because it was more work. It was not easy. And frankly, who knows if it supported the prosecution's case? You will hear Mr. Kuzak give his crime scene reconstruction, and you will hear Professor Blake Van Owen quickly disprove Kyle Kuzak's theory and promote her own. She will tell you that the intruder walked up the front door of Mr. Brackman's home, realized it was locked, and proceeded to the back door where the intruder entered the house and found a sitting Mr. Brackman. He was the object of their mission, not the house. But who was the intruder? Someone who had a strong motive. Someone like Blair Rollins. Blair Rollins was another student at Colorado High School who pledged to avenge his father after Mr. Brackman failed to save him in court. And yet again, the police took the easy path and didn't even try to speak with, let alone investigate Blair Rollins. It was the easy way out to blame Avery Becker and take him to court. Kyle Kuzak and Mr. Markowitz will bring up evidence like scuff marks and knife blocks to try to prove their theory, but every piece of evidence will fall short. You will hear how it is completely impossible to tell when scuff marks are made. You will also hear that no attempt was made to find what type of shoe the scuff marks came from. You will hear how the murder weapon, the bloodied knife, does not even fit the empty place in the knife block that Kyle Kuzak claims it is from. Yet through all this lack of evidence, the prosecution will try to tell you that they did not take the easy way out. Ladies and gentlemen of the jury, this case was rushed. The prosecution took the easy way out. You will not hear any significant evidence and will be left with way more than reasonable doubt. Avery Becker is not guilty of the murder of Mackenzie Brackman or the burglary of his home. Thank you.
Thank you, Mr. Nauman. Allow the scorers just a few seconds to get caught up. And then we will turn to the first prosecution witness. All right, prosecution witness number 1. Let's have counsel identify him or herself again for me. And let's also begin the examination. If counsel is prepared to proceed, let's get started.
Your Honor, my name is Emma Klausner, and I will be doing the direct examination of Detective Jordan Markowitz.
Thank you, Ms. Klausner. Detective Markowitz, you have been sworn and you're on the witness stand. I want to just be certain that I've got your proper name as Abby Miller. Is that right, Abby?
That is correct, Your Honor.
Thank you. You may proceed.
Good morning, Detective.
Good morning.
Please state your first and last name, spelling the last for the record.
My name is Jordan Markowitz, and Markowitz is spelled Markowitz.
And where's your current place of occupation?
I currently work with the Denver Police Department, or the DPD.
How long have you worked with the DPD?
13 years now.
And what exactly is it that you do with them?
Specifically for the last 7 years, I've worked with the DPD as a homicide detective.
And as a homicide detective, what exactly is it that you do?
Yeah, I do just that. I do investigative work on homicides. When the DPD gets a call about a reported homicide, me, often along with a team of other uniformed officers, are some of the first to arrive to the scene. We look over any possible evidence that may be presented at the scene and just start to put some of the pieces together.
And do you have any other specialized areas of expertise?
I do, yeah. I'm in fact certified in cell phone technology and forensic data recovery.
Cell phone data and forensic technology.
Yeah, so all of that is the science of how your phone works and how it communicates with cell towers, as well as how all of that plays into forensic data, and how that works into my role as a homicide detective.
And are there any sort of certifications for working with this material?
Absolutely, yes. As I stated previously, I have a certification in this specific area of cell phone technology and forensic data recovery from the American Academy of Law Enforcement.
And what did this require you to do to obtain this certification?
Yeah, so to become officially certified, I had to take a 3-day course at the American Academy of Law Enforcement, and we learned all about different types of cell phone data, how to obtain it, how to use it, how to interpret it, and then once again, how to apply it to my work as a homicide detective. And then after that, we took a certification test just to show that we were proficient in all of those areas, and obviously I passed, and so now I'm certified.
Your Honor, at this time, I would move to admit Detective Jordan Markowitz as an expert witness in crime scene investigation and cell phone data recovery.
For the defense, any objection or examination?
No, Your Honor.
Ms. Schuman, so there being no objection, the witness will be admitted as an expert in crime scene investigation, cell phone data, and forensic data recovery. Is that correct, Ms. Klausner?
Yes, that is correct, Your Honor.
That being the case, the witness is so admitted, you may proceed.
Detective, I'd like to talk a little bit about Jordan Markowitz's case. Is there anything significant to you about the date March 6th of 2020?
Yes, March 6th was the day that I was in fact called to Mr. Brackman's residence, 444 South Flower Street in Denver, Colorado, and I was called to investigate a reported homicide. Yeah.
And what were your initial observations at the scene?
Yeah, so I initially was called because a passing motorist had seen someone supposedly passed out at the residence, but as soon as I arrived, I noticed that the body present at the scene, which was later discovered to be Mr. Brackman's, was in fact passed away. And so I saw the body, I saw a large stab wound in Mr. Brackman's back that appeared to had caused this fatality, and I as well saw a large chef's knife, that I later discovered was in fact the murder weapon in this case.
So after initial investigation, were you able to obtain any other types of evidence?
I was, yes. Mr. Brackman happened to have a Ring video system installed at his house, which is a sort of dual system, a sort of camera and doorbell. And so I was able to obtain some of that video footage.
Would you recognize these videos if you were to see them today?
I would.
Your Honor, at this time, I am about to present Exhibit 10.
And can you describe for the record what Exhibit 10 is?
Exhibit 10, I'll have my detective explain it. What exactly is Exhibit 10, Detective?
Exhibit 10 is, again, one of the Ring videos that I was able to obtain from Mr. Brackman's Ring video account. In this video, we see an intruder attempt to enter Mr. Brackman's house, and the video is captured on one of 3 Ring video cameras at Mr. Brackman's house. This one happens to be the one aiming near Mr. Brackman's front porch.
Thank you.
Has defense counsel, thank you, has defense counsel had an opportunity to see this video recording? Ms. Schuman?
Yes, Your Honor, I have it here.
All right, you may proceed. I understand the timers will stop timing once the video starts and resume once it ends.
And Your Honor, it looks like we're having technical difficulties presenting this exhibit. I'm trying to.
Your Honor, if it is all right, I don't mind sharing the screen.
Okay, so let me back up a little bit. Based upon the representations of the witness, does the defense have any objection to viewing the video recording?
Your Honor, I would ask that the prosecution enters the exhibit before it is viewed so that the jury does not see it beforehand.
So
Okay.
before so Ms. Klausner, I know you're doing three things at once, so let's pause for a second. Counsel has asked that you lay foundation, that you make me an offer of proof, telling me generally what the origins of this video are, how the witness knows what the video is, and what it generally what is intended to prove.
Yes, so detective, tell me exactly what this video would show us.
Counsel, before the witness responds, my question was directed to you as an offer of proof rather than testimony from the witness. Can you tell the court what the origins of this video are and what it is intended to prove generally?
Yes, so during investigation, the detective was able to obtain a series of videos from Mr. Brackman's Ring doorbell account, and this is intended to explain the effect it had on Detective Jordan Markowitz's investigation.
Is it being offered for the truth?
It is not. It is being offered for the effect it had on the listener.
Based on that offer of proof, Ms. Schuman, do you have an objection to the court viewing, the jury viewing this evidence?
Yes, I do, Your Honor. I would object to hearsay as this video is being used to prove the truth of the matter asserted, as you will see a person within the video, and the prosecution is trying to prove who this person is and what they were doing at the scene of the crime that day.
So what we have is a hearsay objection. I understand from Ms. Klausner, you've said that this is not being offered to prove the truth of the matter asserted if there is an assertion or a declaration in the first place. Any further response to the defense objection before I rule?
Your Honor, I ask for a minute to confer with co-counsel.
All right. You may.
Your Honor, may I respond?
You may.
Detective Jordan Markowitz regularly conducts the collection of evidence in her cases, and so therefore this is a regularly conducted business activity.
All right. This is my ruling. The offer of proof was that this is not being offered for the truth of the matter asserted, and therefore it is not hearsay to begin with, rather than hearsay that is subject to an exception. The defense has disagreed that that is the purpose for which the evidence is offered, but as a preliminary matter, I will find that evidence that is of this sort that is not being offered to prove the truth is therefore not hearsay, and I will overrule the objection and allow the exhibit to be presented, understanding that it is not being offered to prove the truth of its contents, apparently, but is only being proved to show the jury why the law enforcement officers did what they did subsequently. So the exhibit is admitted. Again, tell me which exhibit this is.
This is Exhibit 10, Your Honor.
Thank you. Anything further before we view the video?
No.
Ms. Klausner, thank you. Ms. Klausner, this is your big moment. Run the video and let's see if we can get it to go.
Okay. Co-counsel is currently working on presenting it. Detective, do you recognize this video?
Yes, I do.
What is the video?
The video appears to be one of the ring videos that I was able to obtain from Mr. Brackman's account.
And is it a true and accurate representation?
It is, yes.
Your Honor, at this time I move to bring in Exhibit 10 into evidence.
Okay, I have previously admitted it, but I will again accept that offer and confirm that Exhibit 10 is admitted.
Detective, what does this video show us?
Yes, this video shows us an intruder masked fully.
I'm sorry. This witness cannot testify to the contents of this video as they have just entered it to not prove the truth of the matter asserted, only to prove what effect it had on the detective herself.
Response from Ms. Klausner.
I can rephrase the question.
So the former question is being withdrawn and you are rephrasing, is that right?
Yes, Your Honor.
You may proceed. The objection is sustained for that reason. You may proceed.
Detective, what did you deem to have happened in this video?
In this video, I saw an intruder fully masked in a Halloween mask and a disguise attempt to enter Mr. Brackman's residence. We see them attempt to open what is presumably the front door of Mr. Brackman's residence and fail to do so. And so those were the aspects that I deemed important.
And Detective, through this video, are you able to tell if the entrance was possibly forced or welcomed?
In this video, we see no entrance, and so I'm not able to tell if it was forced or not.
Okay, I can take the exhibit down. We do not need to view it anymore. So were you able to speak to anybody that knew Mr. Brackman personally?
I was, yes.
And who did you talk to?
I spoke with multiple people.
Who were some of those people?
The first person that I spoke with was Alex Cifuentes.
And what kind of things did you talk about with Alex?
Yeah, so Alex ended up being one of the kids that Mr. Brackman coached on mock trial. Through my investigation, I came to realize that Mr. Brackman was a coach for the Colorado High School mock trial team. And Alex Cifuentes happened to be one of the kids on that team. Him and I talked about what mock trial was. Obviously, I'm not too sure what it is, and so he explained that to me a little bit, as well as his relationship with another student on the team, Miss Avery Becker. He also talked to me about their coach, Mr. Brackman.
Excuse me, it appears that counsel has an objection.
Yes, to hearsay, Your Honor.
Your response, Ms. Klausner, to the hearsay objection.
Yes, Your Honor. Again, this is not hearsay because it is not a statement being brought in for the truth of the matter, but rather the effect it again had on Detective Jordan Markowitz in her investigation of the case after hearing Alex's interview.
Ms. Schuman, any response to
No
that
response,
before I
Your Honor.
rule? The court will find that the evidence is not being offered for the truth, but is instead being offered to explain the effect on the listener, and I will then overrule the objection. You may proceed.
And so you say that Alex spoke to you about a relationship between Avery and Mr. Brackman?
Yes, that is the point I was getting to previously. Yes.
How did Alex describe this relationship?
Yeah, Alex explained to me that at least from what he saw, the two of them clashed quite frequently. It sounds like for mock trial, Avery was constantly unprepared, and this triggered Mr. Brackman, causing him to often lash out at her, and the two of them would often conflict verbally, and yeah, it just sounded like they did not get along very well.
Okay, thank you, Your Honor. No further questions.
Thank you, counsel. We'll pause for just a second for the scorers, and then Ms. Schuman, you'll have an opportunity to cross-examine. Ms. Schuman, you may proceed with cross-examination.
Thank you, Your Honor. Hello, Detective Markowitz.
Hi.
So you were assigned to review the case of Mackenzie Brackman.
I was.
You responded to the scene on March 6th of 2020.
I did.
After uniformed officers secured the scene for you.
Yes.
And these officers responded after a passing motorist called 911.
Mm-hmm. Exactly.
And this motorist reported a person passed out on the front porch.
Yes.
And paramedics responded initially,
Yes.
where they found Mr. Brackman dead
Mm-hmm. Exactly.
inside the front hallway.
I'm sorry, could you repeat your question? I couldn't quite understand you.
Inside the front hallway.
Mm-hmm.
And during your investigation, you uncovered Ring doorbell footage.
I did, yes.
One of these cameras that you uncovered was at the front door.
Mm-hmm. 1 of 3.
And this camera was directly above and next to where Mr. Brackman laid.
Mm-hmm. About, yes.
All right. Your Honor, at this time, I would like to share my screen to show Exhibit 10, which has previously been entered.
You may. Exhibit 10 is already in, so you may proceed.
Perfect, thank you. Detective, can you see this?
I can, yes.
Perfect. This is the camera from the front door.
Mm-hmm. It is.
And this camera is not facing the street.
No, it does not appear so.
All right, thank you. And these Ring doorbell footage, you did not have any dates for these videos?
I know the videos that I obtained were from March 6th.
But the exhibits do not have any dates?
No, but when I initially obtained these videos, they were in fact recorded on March 6th.
Perfect. And these videos do not have any time labels either?
No, they do not. But I was able to, if you would not like me to explain further, I don't have to, but.
No, that's okay. Thank you though. At the crime scene, you took photographs?
I did, yes. Along with
took
my team, there were other uniformed officers taking photographs at the scene as well.
Perfect. And you took some photos of blood splatters on the wall?
Not me specifically, but yes.
So your team took photos of blood splatters on the wall?
Mm-hmm.
But these photos were corrupted?
They were, unfortunately, yes.
They were corrupted inside the camera?
Mm-hmm.
And so they were never downloaded off of the camera?
Unfortunately, yes. If we would have had a chance, we would have, but I mean, mistakes happen. They were corrupted.
Yes. And you were suspicious that one of Mr. Brackman's former clients could have done this?
I was initially, but after following up, it didn't appear that that could really be a possible lead.
But you never followed up. You didn't.
As I stated previously, after doing a little more investigative work, it didn't appear that any possible leads could result from looking further into that, so no.
Detective, but you never suspected any former ex-clients.
I didn't, because as I've previously stated, there didn't appear to be any that had any sort of incriminating evidence against them.
In fact, you only ever spoke to one student.
I did, and I spoke with Alex Fuentes, who gave me my biggest break in the case.
Perfect. And you did not speak to anyone else on the mock trial team?
I didn't. I attempted to speak with Miss Becker herself, but a few hours before our interview was supposed to occur, I got a call from her attorney saying that the interview would not happen. So there was an attempt made, but in the end, yes, you are correct. I only spoke with Alex Fuentes.
Okay, thank you. And you did not receive any call detail records for Alex Fuentes' phone?
I did not, but I did receive some information from.
Even reached Alex Fuentes' phone?
I did not. I got screenshots from his phone, though.
And these screenshots were taken by Alex Fuentes himself?
They were, yeah.
So you obtained a warrant to search Avery Becker's phone?
I did. But once again, as I referenced earlier, I spoke with her attorney, and this attorney informed me that Miss Becker's phone had been lost, and so I was never able to download the contents.
That's fine, but so the answer to my question was that you never obtained a warrant to search Avery Becker's phone?
No, I did in fact obtain a warrant. I just was never able to follow through.
Perfect, thank you. And you did not obtain warrants for any other person's phone in this investigation?
I did not. No, there didn't appear to be any evidence that could have come from it, and so no, I did not.
Okay, perfect. And then you were not able to search Avery Becker's phone?
Once again, as I've stated previously, Miss Becker's attorney informed me that her phone had in fact been lost, and so unfortunately, no, I was not able to search her phone.
Yes, and it was lost on March 5th of 2020?
Supposedly, yes.
And that is the day before the crime?
Yes.
So you received call detail records for Avery Becker's phone?
I did, yes.
For March 6th of 2020, the day of the crime?
Mm-hmm.
All right, at this time, Your Honor, I would like the witness to direct her attention to Exhibit 15 and 16.
Yes, if you'll just allow me one moment to find it. Okay, I have them both up.
Perfect. So these are the diagrams of the call detail records?
Yes, that I created, yes.
And you made these diagrams?
I did, in fact, yes.
So these are fair and accurate representations of the diagrams?
Absolutely.
Perfect. At this time, Your Honor, I move to enter Exhibit 16 and 15 into evidence.
Any objection from Ms. Klausner?
No objection, Your Honor.
Exhibits 15 and 16 will be admitted. Do you intend to display them at some point, Ms. Schuman?
Yes, Your Honor. I intend to right now.
Thank you.
All right. Sorry, this is going to be a little bit difficult just because we're not able to. All right, there we go. Detective, what is this exhibit?
Yes, as we've talked about previously, this exhibit is the diagram that I made representing the CDRs I collected from Miss Becker's cell phone number.
And at 12:47 p.m. on March 6th of 2020, the phone was in the top tower labeled 1227.
Yes.
Perfect. And at 1:17 p.m., the phone was in the bottom left tower labeled 1197. Perfect. And the top left tower named 1227 covers Avery Becker's home,
Yes,
And this tower as well covers Blair Rollins' home.
it does. Yes.
Perfect, thank you. So you used these call detail records to come to a conclusion about this case,
I did, absolutely.
but you only received records for March 6th of 2020.
I did.
You did not obtain records for the morning of March 6th?
I did not. I took them from about noon until that afternoon.
Okay, and you did not obtain records for the night before the crime?
I did not. I didn't think that any incriminating evidence would come from it. And so, yes, I only collected them for that afternoon.
And you did not obtain records for the afternoon of the crime, after the crime had been committed?
Not following around 1:30 that afternoon, no.
Right, and you did not obtain records for Taylor Perkins' phone?
No, I did not.
And you did not obtain records for Alex Fuente's phone?
As we've discussed previously, no, I did not, because I didn't believe it would be any importance to do so.
And you did not obtain records for Blair Rollins' phone?
I did not, no.
Perfect. Thank you, Your Honor. No further questions.
Thank you, Ms. Schuman. Any redirect based on the cross-examination we just heard, Ms. Klausner?
Yes, Your Honor, a brief one.
You may proceed.
Detective, you only thought of Avery Becker as the feasible, Avery Becker in your mind was the only feasible person to investigate for Mr. Breckman's case, correct?
Yeah. Yeah, I'm assuming you're referencing suspects in this case. And yes, Ms. Becker did appear to be the only possible suspect in this case.
And so you did not feel a need to follow up on call detail records from any other individuals?
Not at all. Ms. Becker's phone gave me and my team of police officers all the information we needed.
Perfect. Thank you.
The court will thank the witness and will not permit any further recross at this point. Let us proceed to the prosecution's next witness. While we're getting the next witness seated, we'll let the jury spend a little time updating their score sheets. I do want to caution counsel that commenting on the evidence is inappropriate. The expression perfect has been used by both the prosecution and the defense during their examinations, and I would caution counsel not to comment on the evidence during their examination. Let us call the prosecution's second witness. Identify yourselves, please. Is counsel prepared to examine the prosecution's second witness? I see faces, but I see mics muted. All right, I'm going to ask Ms. Klausner, can you hear me? Okay, so we may be having technical issues. Ms. Klausner, can you hear me? Raise your hand if you can. All right, everyone, stand by. I believe we are having technical issues. I see someone on my screen. I see Rachel. Rachel, can you hear me? Raise your right hand. And
yes, I can hear you just fine.
okay, and there's a lawyer to your left on my screen. Marie, I can't get your full name. Can you hear me?
I can, Your Honor.
Okay, so are you, what I'm trying to figure out is who is examining this witness? And why is no one responding to me?
Your Honor, I am cross-examining this witness for the defense.
Thank you. So for the prosecution, it would appear that Ms. Thompson is having audio issues. So we will need to take a moment to get her back online. Now I can understand why she did not respond. So counsel that just responded to me, the defense counsel, what is your name?
My name is Maren Napolitano, Your Honor.
Oh, Ms. Napolitano, you may leave your mic unmuted at this point because I want to make sure that I get a rapid response from you.
Thank you, Your Honor.
And Ms. Thompson, are you able to hear us yet? Raise your hand if you can.
Yes, I can hear you.
All right. And so, Ms. Thompson, are you conducting direct examination of this witness?
Yes, Your Honor, I'm conducting the direct examination of Kyle Kuzak.
Okay, you may proceed. Ms. Napolitano, you may mute now. Thank you. Ms. Thompson, your witness.
Please state your name, spelling your last for the record.
My name is Kyle Kuzak, Kuzak.
What do you do for a living, Ms. Kuzak?
I'm a crime scene reconstruction investigator.
What does that mean?
Well, I work closely with police forces, and when they come across complex crime scenes, they call me in, and basically what I do is I investigate, I analyze the crime scene, and try and give my best conclusion or hypothesis to what happened at that crime scene.
How long have you been doing this?
I've been in crime scene reconstruction for 19 years, but the last 3 I've spent with the City of Denver Police.
Are you considered a police officer?
No, I'm a civilian employee.
What does it mean to be a civilian employee?
Well, basically, I get assigned cases by the police department. They pick and choose which ones they need my help on.
How, do you have any processes that you follow during this?
Yeah, I try and go into every case with 2 key principles. I assume every case goes to trial, so I try and make my evidence in a way that it can be understood by the untrained eye or person. And then my second key principle is I try and collect everything with with a mindset of future reconstruction. So if any new evidence comes up, any new suspects, we'll be ready.
Your Honor, I now move to admit Kyle Kuzak as an expert in crime scene reconstruction.
Any objection, Ms. Napolitano?
I have no objection, Your Honor.
The witness has been qualified and will be admitted to render opinions on crime scene investigation. Ms. Thompson, you may proceed.
Were you an investigator on the murder of Mackenzie Brackman?
I'm sorry to interrupt, Your Honor, but I believe that she was admitted as a crime scene reconstructor, not as an investigator.
Ms. Thompson, can you clarify that for me? I know
Yes.
you've gotten it wrong.
It was a crime scene reconstruction investigator.
Forgive me. I stand corrected. Thank you, Ms. Napolitano. You may proceed.
Were you an investigator on the murder of Mackenzie Brackman?
Yes, I was.
Did you use any other policies besides your 2 policies during this investigation?
Yeah, well, I used my 5-step process that I try and use for every case. Do you want me to explain it?
Yes.
Well, the first step is recognition and documentation. This is when I create witness tracking spreadsheets, evidence tracking spreadsheets, and flowcharts. My second step is collection of evidence. I collect anything from police reports to ME reports. And then my third step is analyzation of evidence, and that one's kind of self-explanatory. My fourth step is hypothesis and testing. I try and come up with the best possible explanation for what happened on that day. And then the fifth step is my final conclusion. This includes peer reviews and basically just finalizing what I think happened.
Did you use this 5-step process during the investigation of Mackenzie Brackman?
Yes, I did.
Were you able to visit the crime scene?
Yeah, I went there after multiple other members of the crime lab had already analyzed it.
What did you do when you got there?
I analyzed it.
Do you have a process that you follow during your analyzing?
Yeah, well, I used my 5-step process, and like I said, I went into this case with my 2 key principles.
With your crime scene reconstruction, how do you think the murder of Mackenzie Brackman happened?
Well, an intruder entered the home of Mackenzie Brackman through the back door. Mr. Brackman was alerted either by the Ring video system app or the intruder entering their back door. Mackenzie Brackman proceeded to arm himself with a knife that he found in his kitchen counter knife block. And there was some kind of struggle between the intruder and Mr. Brackman, but ultimately the intruder ended up with a knife and then stabbed Mr. Brackman. Mr. Brackman walked across his floor for a couple steps and then proceeded to pull the knife out of his own back, where he then collapsed and bled to death.
During your investigation of the murder of Mackenzie Brackman, did you make any flowcharts or any other documentation?
Yeah, like I said, I made a witness tracking spreadsheet, evidence tracking spreadsheet, and a flowchart.
Would you recognize a copy of this flowchart if presented to you?
Yes, I would.
Your Honor, let the record reflect. I am screen sharing Exhibit 17, the last page.
The record will so reflect. Has counsel seen a copy of this, Ms. Thompson?
I believe they all have a copy of the exhibits, but if not, we can screen share it.
Ms. Napolitano, will you confirm that you've seen a copy of this document?
I have seen a copy of this document, Your Honor.
Thank you. Ms. Thompson, what is the number that's been assigned to this document?
Exhibit 17.
Thank you. You may display it for the benefit of the witness.
Thank you. Do you recognize what I've screen shared?
Yes, I do.
And what is it?
This is the flowchart I created early on in my investigation.
Is it a fair and accurate depiction of the flowchart?
Yes, it is.
Your Honor, I now move to admit Exhibit 17 into evidence.
Ms. Napolitano, you may unmute. Do you have any objection to this Exhibit 17?
I do. I object to hearsay with this exhibit.
All right, there's a hearsay objection. Ms. Thompson, I'll give you an opportunity to respond.
Under Rule 803, subsection 6, records of a regularly conducted business activity, as Ms. Kuzak has explained before, she has made other flowcharts and other documentation during her other investigations. So this is a regular business activity that she does during each of her investigations.
Ms. Napolitano, your reply.
Yes, my reply would be that usually would apply to police report work. And as this witness has testified, she is not technically served as a police officer. So yes, thank you.
Your Honor, may I respond?
I will.
Oh.
Yes, briefly.
There's nowhere in the rule that states that it's a police officer that needs to have these records. As Ms. Kuzak has explained, she's been in this business for 19 years, and this is something that she does with each of her investigations.
I will overrule the objection, the reason being that the witness has laid an appropriate foundation to establish this as a business record. And I do agree with counsel that that the witness need not be a police officer in order to have a record of a regularly conducted business activity admitted as an exception to the hearsay rule. So Exhibit 17 is admitted and may be published.
Ms. Kuzak, is there anything about this flowchart that stands out to you?
The only thing that's irregular about it is you see the small arrow in the middle of the exhibit pointing left and then upward towards a different possibility. These both represent the timing, both possible timings where the victim could have armed himself with the knife.
Did you use this flow chart to help you come up with your conclusion?
Yes, I did.
And do you mind briefly explaining your conclusion to the jury?
Yeah, sure. Well, basically, this was, I think, a burglary
Objection,
gone
Your
wrong.
Honor, asked and answered. This witness has previously testified that what her conclusions were regarding this scene, and there is no need for her to restate that.
I will allow Ms. Thompson an opportunity to respond. I seem to recall the witness did explain her conclusions. Is there something more that you want me to consider here before ruling?
Yes, Your Honor. Ms. Kuzak is explaining how this flow chart fit into her conclusion, to explain how her process helped with the conclusion that she made before she was explaining the overall conclusion, and she's explaining what stood out in this flow chart and why it's prominent in this conclusion.
May I respond, Your Honor?
You may.
I was just going to say that I believe the question asked her to state her conclusions, not what this flow chart meant for her conclusions.
I agree. I will still overrule the objection, and here is why. The objection is a 403 cumulative redundant, but the other part is whether it will unfairly prejudice or confuse or mislead the jury. And I don't believe that that is the case with respect to this question, so I will allow the witness to respond. The objection is overruled.
Do you mind explaining how this flow chart helped you come up with your conclusion and what your conclusion was?
Yeah, of course. I always find flowcharts helpful, but this just gives a better visual representation of what I do believe happened. The victim was in his own home alone, and I mean, this flowchart really just explains kind of step by step what happened.
Thank you. No further questions.
Thank you. We'll pause for just a moment, Ms. Napolitano, before cross-examination. Ms. Napolitano, you may proceed with cross-examination. You have 7 minutes, 13, strike that. You may proceed, sorry.
Thank you, Your Honor. Ms. Kuzak, you went to the scene at 444 South Flower Street.
Yeah, I did.
After it was processed?
Yes.
You reviewed photographs others took of this scene.
Yeah, I did.
Some of these photographs showed blood droplets between the kitchen and the front door.
Yes, they did. They were very helpful for my investigation.
As well as photos of cast-off.
Yeah.
But those photos are no longer able to be viewed.
Yeah, unfortunately, something happened with the file. It was corrupted or something.
So
that was
no
after
one
I
is
looked at
able
it.
to see these photos, Ms. Kuzak.
No, not today.
But you saw these photos.
Yes, I did.
And you used them in your review?
Yeah, I did.
And you came to your conclusions based on physical evidence at the scene, correct?
Among other things, yes.
Some of this evidence would include scuff marks.
Mm-hmm.
Or ring videos.
Yep.
Or a broken plate.
Yeah.
But using all of this evidence, you were not able to recreate all of the event segments.
Unfortunately not. Crime scene reconstruction isn't an exact science.
And you were not able to place all of the pieces of evidence, correct?
I'm sorry, I don't understand your question.
You were not able to place all of the pieces of evidence you found, correct?
I'm sorry, I'm still having trouble understanding.
That's all right. We can move on. And you said that you found there was limited evidence and would have preferred more.
Oh, well, every crime scene reconstruction investigator does.
And you just testified that you have looked at scuff marks.
Mm-hmm.
But you did not analyze those scuff marks.
No, I didn't.
To see if they matched the shoes of Mr. Becker.
Nope.
Or Mr. Brackman.
No, I didn't.
Or any other person's shoe.
No.
You have watched all of the Ring security videos regarding this case, correct?
Yeah, I have. They were really helpful.
Including the video from Exhibit 10, which has previously been entered into evidence,
Yes.
which showed the intruder coming up to the house.
Mm-hmm.
And you concluded from these videos that the victim was not alerted by the Ring app.
No, it is still a possibility.
But you stated that you concluded the intruder was not surprised.
I'm
By the
sorry.
Objection, Your Honor, hearsay.
Right,
Your Honor,
you may respond.
this is not hearsay. As I'm simply trying to lay foundation for this chapter, it's not being offered for the truth of the matter asserted.
Response from Ms. Thompson?
Your Honor, then I would also question relevance of why this is not being brought in for the truth of the matter asserted, and why it's being brought up at all if what she's saying is not offered for the truth of the matter.
May I respond, Your Honor?
You may.
Your Honor, if I'm allowed to continue this line of questioning, you will see that this is incredibly relevant to Ms. Kuzak's reconstruction of this case.
Your Honor, may I respond?
No, I'm prepared to rule, Ms. Thompson. The council has given a good faith reason behind the inquiry. I also am not certain that the inquiry asked for a hearsay response, but I will allow council a bit of leeway in this line of questioning and therefore will overrule the objection.
Thank you, Your Honor.
And Ms. Kuzak, you are a crime scene reconstructor.
Yes, that's what I do.
And you were not given records of Mr. Brackman's phone accounts.
Why would I have been?
You did not investigate his app settings.
No. Like I said, I'm a crime scene reconstruction investigator. I go to the scene and I reconstruct the crime scene.
So you don't have evidence to support the claim that he was surprised by the intruder. Is that correct?
That's correct in aspect to the Ring videos, but the intruder opening the back door and Mr. Brackman then being alerted is also a possibility. Both of them are options.
And you just said that you used the evidence to reconstruct.
I used all the evidence to reconstruct, yes.
Including a knife found at Mr. Brackman's home?
Yeah.
Would you be able to recognize a photo of this if it was presented to you?
I would.
Your Honor, I would like to direct Ms. Kuzak's attention to what has been previously marked for identification purposes as Exhibit 5.
Has counsel for the prosecution seen Exhibit 5?
Yes, Your Honor.
All right, you may display Exhibit 5 at this point.
Ms. Kuzak, this is a picture of the knife found at Mr. Brackman's home, correct?
Yes, it is.
Is it a fair and accurate representation of that photo that you saw?
It looks like it, yes.
Your Honor, permission to enter exhibit what has been previously marked for identification purposes is Exhibit 5 into evidence.
Any objection, Ms. Thompson?
No, Your Honor, no objection.
Ms. Kuzak, you will notice that this has a silver handle.
Yes.
And you have looked at a knife block regarding this case, correct?
Mm-hmm.
And in that knife block, you have stated, you can see that all of the knife handles are black, correct?
Yes, they do appear to be that way.
But you concluded that this knife came from that knife block. Is that correct?
Yes, it is.
No further questions, Your Honor.
Thank you, Ms. Napolitano. Ms. Thompson, redirect.
Yes, Your Honor, a brief one. Ms. Kuzak, is it a part of your job to investigate people's phones?
No, I reconstruct crime scenes.
Is it a part of your job to collect evidence?
Partially, but that's mostly the police's work.
Thank you. No further questions.
Thank you. The witness is excused. We will pause for a moment to allow the scorers to get caught up, and then we will proceed to the prosecution's third and final witness. While the scoring jurors are keeping track of their scores, let us introduce the witness and then counsel for the prosecution, who will be doing the direct, and counsel for the defense doing the cross-examination, just so we keep track of who's who. The prosecution may proceed with their third and final witness. All right, I see Ms. Thompson. I see Mr. Give me your last name again, Mr.
Nauman.
Nauman,
Your
thank you,
Honor.
sir.
Yes, thank you.
Yes.
Your Honor, if we could just have a moment to change names to make it easier for the jury.
Okay, that's fine. We'll make it easy for the jury. Who's changing their names?
I am.
Okay. Mr. Nauman, you're crossing the witness, is that right?
Yes, Your Honor.
Thank you. And I see Shanti Grossman. Are you the witness, serving as the witness today?
Yes, Your Honor, I am.
Thank you. And then I now have Raven Chamberlain here on my screen. Are you serving as direct examination for the prosecution?
Yes, Your Honor.
All right, now that I've got everybody squared away, let us proceed. You may examine the witness.
Good morning, Ms. Cifuentes.
Good morning.
Please state your name and spell the last for the record.
My name is Alex Cifuentes, Sifuentes.
And are you currently enrolled in school?
Yes, I'm a senior at Colorado High School.
And do you participate in any extracurriculars there?
Yes, I'm on the mock trial team.
And do you know anyone on the mock trial team?
Yeah, my very close friend Avery Becker is on the team, as well as Taylor Perkins.
And could you tell me a little bit about your relationship with Avery Becker?
Yeah, Avery and I have been friends for a while. Avery was actually the one who introduced me to mock trial.
And from what you observed being on the team, how did Mr. Brackman and Avery act towards each other?
From what I observed, they seemed to be constantly frustrated with each other. Mr. Brackman seemed to be frustrated with Avery's lack of preparation and not showing up on time, and Avery seemed to be upset that Coach had recognized that.
Is there an objection, Mr. Nauman?
Yes, speculation.
Lack of personal knowledge is the objection, Ms. Chamberlain?
I think that my witness was just telling me what she noticed being on the team with Avery.
Perhaps you could lay a little better foundation to support this. I will overrule the objection, but ask that you lay a bit better foundation for the observations the witness is making.
Okay.
And by that, I mean, how does the witness know how people seem to be feeling?
Okay. And how did you know that Avery felt that way towards Mr. Brackman?
It was very obvious in the conversations and just things that had happened in practice. It was very obvious to myself as well as other teammates, their emotions.
And were there any large conflicts that you know of between the two of them?
I believe the largest conflict was directly after our regional competition.
And what happened during that conflict?
At the regional competition, Avery had won a Best Attorney Award and Best Closing Award. And at the next practice, Mr. Brackman told Avery that he did not believe that Avery deserved the awards that Avery had received at.
Objection?
Yeah, hearsay, Your Honor.
Ms. Chamberlain, the objection is hearsay. Your response?
This is not hearsay because it is present since impression.
Any reply to the exception to hearsay?
I stand by my previous objection, Your Honor.
I will overrule the objection. I will find that counsel has offered a good faith explanation as an exception to the hearsay rule for a then existing present sense impression. The witness may continue.
Would you like me to repeat my question?
Yes, please.
And what happened during this conflict?
Like I said, at the regional competition, Avery had won a Best Attorney Award and Best Closing Award. At the following practice, Coach Brackman told Avery that they did not believe that Avery deserved the awards that they had received.
And do you know how Avery reacted to this?
Yes, Avery got outwardly frustrated and grabbed a marker and ran out of practice and wrote Worst Attorney Award on Coach Brackman's car.
And do you know if there were any consequences for Avery after this?
Yes, Coach Brackman decided to kick Avery off the team permanently.
And do you know if Avery contacted anyone after this?
Yes, Avery reached out to me.
And what did she say?
Avery had asked me if I was willing to talk to Coach about letting Avery back on the team.
And did you talk to him?
Yes, I did.
And did he let her back on the team?
No, he was not willing to.
And did you tell Avery this?
I did.
And how did she respond?
She responded by saying that if Coach was upset about what happened to his car, then he should see what's going to happen to his house.
And did she ever tell you what she was going to do to his house?
Yes, I asked, and she said that she was going.
Excuse me, what's the objection is what, sir?
Hearsay, Your Honor.
The objection is hearsay, Ms. Chamberlain. Your response?
This is not hearsay because it is party opponent.
I will agree with that. The objection is overruled. It is a statement of a party opponent against that party's interest. You may proceed.
Would you like me to repeat my question?
Yes, please.
How did Avery ever tell you what she was going to do to his house?
Yes, I asked, and she said that she was going to break in to Mr. Brackman's house and trash it.
And did you think she was serious?
Absolutely.
And how did you respond?
I said I didn't believe that was a good idea.
And how did Avery contact you?
Avery texted me.
And would you recognize a copy of these texts if you saw them here today?
Yes.
Your Honor, I would now like to screen share what has been previously marked Exhibit 14.
You may for purposes of witness examination.
Do you recognize these?
Yes, I do.
What are they?
This is my text conversation with Avery.
And does it appear to be a true and accurate copy?
Yes, it does.
Your Honor, I now move to admit what has been previously marked as Exhibit 14 into evidence.
Mr. Nauman, any objection to Exhibit 14?
No objection, Your Honor.
Exhibit 14 will be admitted and deemed published. You may proceed.
No further questions.
Mr. Nauman, you now have an opportunity to cross-examine the witness. You may proceed.
Okay, give me 1 second, Your Honor. All right. You presented screenshots to the police.
Yes, I did.
Screenshots of text messages.
Yes.
Texts from Avery Becker's phone.
Text from Avery Becker, yes.
With no timestamp.
No.
And you gave the police nothing except these screenshots.
I offered to bring my phone in, but they did not want it. They asked for the screenshots.
But you did not show the detective your phone.
No, I did not.
The only piece of concrete evidence that you had.
I, like I said, offered to bring in the phone and they didn't want it. Detective Markowitz said that the screenshots would suffice.
So you never showed them your phone?
No, I did not.
The phone that contains a vital piece of evidence for this case?
Correct.
And the police asked you for nothing more than these screenshots?
Correct.
And you were at Fry Shack the day before the murder?
Yes.
After you claim you received the text from Avery Becker?
When I did receive the text from Avery Becker.
The text that threatened Mr. Brackman's home?
Correct.
You saw Avery Becker and Taylor Perkins at the Fry Shack?
Yes.
And you played a game?
Yes.
On Avery Becker's phone?
Yes.
Just before she left?
Correct.
You were on the mock trial team with Avery Becker?
Yes, I was.
You were both similarly skilled at mock trial?
I believe so, yes.
But Avery rarely put any time into practice?
From what I saw, that is correct.
And you put hours and hours into mock trial?
I did.
And at practice, Avery got better or similar or even better results than you?
Correct.
And this made you mad?
It was definitely frustrating for me.
And later, Avery Becker was let back onto the A team after Taylor Perkins quit?
Yes.
And this made you especially annoyed?
It was, again, frustrating for me.
And Avery even won Best Attorney and Best Closing at regionals?
Yes, she did.
And you thought the team was better without Avery Becker?
I do believe that, yes.
And you were excited for a bigger role in Avery's absence?
Yeah, I was.
Thank you, Your Honor. No further questions.
Thank you, Mr. Nauman. Ms. Chamberlain, any follow-up examination? Redirect.
No, Your Honor.
All right, that concludes this witness. This witness is excused. We'll pause for a moment for the jury to get caught up with their scoring. And we will, while I'm at it, ask lead counsel for the prosecution, Ms. Thompson, strike that, Ms. Klausner, does the prosecution rest?
Yes, Your Honor.
Thank you. We will then proceed to the defense case. The first defense witness you may call. Please identify yourselves just so I'm clear on who's who.
The prosecution calls Blake Van Owen to the stand.
Thank you, Mr. Nauman. Blake Van Owen, step forward. And who for the prosecution is cross-examining?
I am, Your Honor.
And that is Ms. Thompson, right?
Yes.
Okay, because I've got a different name, but I think I recognize you by now. So that
Yes,
being the case, Mr. All right, thank you. If you can change that name while you're multitasking here. Mr. Nauman, you may proceed with the defense witness one. And I've got Blake something at the bottom of the screen. Will the witness please give us your real name, just for the record?
Yes, Your Honor. My name is Paige Weidman.
Paige Weidman. Okay. Mr. Nauman, you may proceed.
Please state your name and spell your last for the record.
My name is Professor Blake Van Owen, VAN space OWEN.
Professor Van Owen, what is your current job?
I am a private investigator and professor.
What are some of your previous jobs?
I was employed in the Aurora Police Department as a police officer. I worked as a school resource officer and as a private security guard.
You mentioned you were a professor. What classes have you taught as a professor?
At the Community College of the Rockies, I taught a course on police procedures. And at CU Denver, I taught a course on both police practices and social justice.
Have you been recognized as an expert in previous cases?
Yes, I have.
What fields have you been recognized as an expert in?
I've been recognized as an expert in numerous fields, but for the sake of this case, I believe it is imperative for me to mention that I was recognized as an expert in cell tower data analysis, general police investigation tactics, and crime scene reconstruction.
How many states have you been recognized as an expert in?
I've been recognized as an expert in 3 district courts and 4 state courts.
Could you describe what cell tower analysis means?
Yes, cell tower data analysis is the analysis of information that can be gained from cell towers. This can encompass from any given period of time, the geographic location of a phone, and the actions taken on a phone, including phone calls or messages.
Could you describe what police investigation tactics means?
Yes, I can. Police investigation tactics are exactly what it sounds like. They are the investigation tactics used by the police force.
How many times have you been recognized as an expert in these fields?
I have been recognized as an expert over 100 times.
And do you have any formal training in these fields?
Yes, I do. I earned my master's degree from Ashford University's online program. And other than that, my knowledge comes from the sheer amount of time I've spent both as a police officer in regards to police investigation tactics and as a private investigator.
Your Honor, I now move the court to recognize Professor Blake Van Owen as an expert in crime scene reconstruction, cell phone data analysis, and police investigation tactics.
Any inquiry or objection by you, Ms. Thompson?
Yes, Your Honor. Can I perform a brief voir dire?
You may.
Miss Van Owen, you were only a police officer for 8 months.
9 months.
9 months. And
all of the training necessary.
But you haven't been a police officer for a long time now.
I haven't been a police officer since 2005 to 2006.
So you're not up to date on their new practices.
Well, the police investigation tactics have not changed much since I was a police officer.
But you wouldn't know that because you're not currently a police officer.
I work directly with the police as a private investigator.
But you're not currently a police officer, so you don't know how much the techniques have changed.
I am not currently a police officer, no.
Thank you. No further questions.
Any objection to the witness being qualified as an expert as offered?
I do object to police practices, Your Honor.
And Mr. Norman, I heard crime scene reconstruction, cell phone, something, and then the third element was it crime scene? Tell me again what that last element was.
Crime scene reconstruction, and then the other one was cell phone data analysis.
So those 2 fields, correct, is what you're offering
yes.
this witness as an expert?
And police investigation tactics.
Your Honor, I object to police investigation tactics as well as crime scene reconstruction. May I explain my objection?
You may.
Miss Van Owen has never been established as a crime scene reconstruction investigator. They've never done work as a crime scene reconstruction investigator, were never trained as a crime scene reconstruction investigator. They were also a police officer over 10 years ago and are not up to date on any of the new practices. And as they mentioned, they were only a police officer for 9 months. And that is, I stand by my objection.
Your Honor, may I respond?
Although No, I'm prepared to rule. I find that a sufficient foundation has been laid to qualify the expert as offered and to render opinions in these fields. The weight of the witness's testimony will be left to the jury. So the objection is overruled and the witness will be admitted to render opinions on crime scene reconstruction, cell phone something, and police investigation tactics.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Mr. Nauman, you may proceed.
Professor Van Owen, why did you leave the police force?
I left the police force after I was involved in an incident where I injured a young woman. I was officially legally cleared of all wrongdoing, but my moral compass just cannot excuse that abuse of power.
Professor, have you reviewed Mr. Kuzak's crime scene reconstructions?
Yes, I have.
And have you reviewed Mr. Markowitz's cell tower reports and exhibits?
Yes, I have. But on top of reviewing Ms. Markowitz's cell tower reports and exhibits, I did complete my own investigation.
Why did you perform your own investigation?
Many areas of this investigation were entirely neglected by the police. This was a rushed investigation, and the police came to the easy conclusion.
Did you review the videos from the security cameras in your crime scene reconstruction?
Yes, I did.
Could you give a quick summary of the information you gained from these videos?
Yes. The first video showed the intruder wearing a mask that obstructed their face. They tried to enter the premise of Mr. Brackman through the front door. However, that door was locked.
Hold on, sorry. Do these videos give a path that the intruder took to the entrance?
Yes, it shows how the intruder entered the dwelling of Mr. Brackman.
As for the physical evidence on the crime scene, what did you find on the interior of the house?
I did find some scuff marks near the backsliding door.
Do you know how old these scuff marks were?
Not at all. Those scuff marks could have been from 2007.
And were they ever analyzed to find which pair of shoes they came from?
No.
Was there anything else that seemed directly related to the murder?
To use directly, loosely, there was a knife block. However, the specific knife used in the murder is a completely different brand of knives than those in the knife block. And in fact, it doesn't even fit into the empty slot in the knife block.
Professor Van Owen, do you have a copy of your exhibit notebook in front of you?
I do, yes.
I would now ask that opposing counsel direct their attention to what has been previously marked for identification purposes as Exhibit 8. And Professor Van Owen, could you also direct your attention to what has been previously marked as Exhibit 8, or as Exhibit 8?
Yes.
Do you recognize this picture?
Yes, I do. This is a picture of the knife block in Mr. Brackman's kitchen.
Is this a fair and accurate representation of the knife block at or about the time of the murder?
Yes.
Your Honor, I will now share this exhibit on the screen.
Has counsel for the prosecution seen this exhibit, sir?
Yes, Your Honor.
Thank you, Ms. Thompson. Mr. Nauman, you may proceed.
Do you recognize this knife block?
Yes.
And could you direct your attention to what has been previously entered as Exhibit 5?
Yes, I can.
What do the knife handles in Exhibit 8 look like?
In Exhibit 8, the knife handles are black with a silver line.
Excuse me, Mr. Nauman, before you inquire of the witness any further with respect to the contents of Exhibit 8, can you offer it and allow counsel an opportunity to respond?
Oh, sorry, Your Honor. Your Honor, I now move the court to enter Exhibit 8 into evidence.
Any objection to Exhibit 8, counsel for the prosecution?
No objection, Your Honor.
Exhibit 8 is admitted and deemed published. You may proceed, Mr. Nauman.
Thank you. Could you describe the knives in Exhibit 8?
Yes, they have a black handle, a black round handle with a silver stripe through the middle.
And could you describe the knife in Exhibit 5?
Yes, the handle is completely different. It is brown, and the shape is also radically different.
Thank you. I will now stop sharing my screen. Give me 1 second. Now to move on to Avery Becker's cell phone. Can you confidently say that Avery Becker's phone was at Mr. Brackman's house?
No, I cannot. In regards to cell phone tower data, I did mention that it can show the geographic location of a phone, but that is very, very broad.
Can you tell the jury about the range of these cell towers?
Yes, in very urban areas, a cell phone tower has a radius of about 6 to 7 miles.
And Professor Van Owen, do you have your exhibit notebook in front of you?
Yes, I do.
I would now ask that opposing counsel direct their attention to what has been previously marked for identification purposes as Exhibit 15.
I assume council has a copy of Exhibit 15 to refer to.
Yes, Your Honor.
All right. Go
Professor
ahead,
Van
Mr.
Owen.
Nauman.
Sorry. Professor Van Owen, do you recognize this exhibit?
Yes, I do. This is a map detailing the location of the cell towers around the victim's house and the suspect's house.
Is this a fair and accurate representation of the orientation of these specific cell towers on the day of the murder?
Yes, it is.
And are these the correct locations of Avery Becker, Blair Rollins, and Mackenzie Brackman's homes on the day of the murder?
Yes.
Your Honor, I move the court to enter what has been previously marked as Exhibit 15 into evidence.
Any objection, Ms. Thompson?
Your Honor, I ask that it's screen shared first so we can make sure it is a fair and accurate depiction.
Mr. Norman, can we see Exhibit 15, please?
Yes, Your Honor.
Any objection to Exhibit 15?
No objection at this time, Your Honor.
I believe exhibit, I'm looking at my notes, we've already admitted 15, so forgive me for not catching that earlier. Mr. Nauman, you may proceed.
Okay. Can you tell the jury about the range of these specific cell towers?
Considering the population density surrounding these towers, it is likely that the radius is around 6 to 7 miles.
And could you direct your attention to what is previously entered as Exhibit 16?
Yes, I can.
Do you see the path on this photo?
Yes, I do.
Is this a confirmed path?
No, it isn't.
Objection, Your Honor. Opposing counsel has not been presented or asked if they have Exhibit 16.
According to my notes, Exhibit 16 was admitted by the prosecution. Am I mistaken there, Ms. Thompson?
No, you're not mistaken. That was my mistake.
Okay, so Exhibit 16, you may continue your inquiry.
Thank you, Your
Mr.
Honor.
Nauman.
How are you able to tell where the phone actually did travel?
Well, Avery Becker's phone was receiving multiple texts and calls from Taylor Perkins at this time. And the cell towers were connecting to Avery's phone in order to transmit these calls. And yes, that is how I can tell.
Do you have any phone records for the morning of or the night before the murder?
No, I was not provided with any.
And why might those be important?
Well, they could show whether the phone was at Avery Becker's house, or Alex Fuentes' house, or any other suspect's house before and after the murder.
Based on your investigation, were there any other alternative suspects?
Yes, based on my investigation, there was a potential suspect named Blair Rollins that the police didn't bother questioning.
And you mentioned text from Taylor Perkins. Where was he at the time of the murder?
I checked the phone tower data from Taylor Perkins' cell phone on that day, and there is a call from his phone corresponding with every single missed call on Avery Becker's.
Was there any other evidence collected from cell phones?
Yes, there were screenshots from Avery Becker to Alex Cifuentes.
Are screenshots a reliable piece of evidence?
No, they can easily be manipulated. It is much better, to conduct a full examination of the phone.
Thank you, Your Honor. No further questions at this time.
Thank you, Mr. Norman. We'll allow the jury a few seconds to get caught up, and then we will proceed with cross-examination. Ms. Thompson, your witness.
Thank you, Your Honor. Good afternoon, Miss Van Owen.
Good afternoon.
We're going to talk a little bit about your old job. You used to be a police officer,
Yes.
and you quit after you were sued.
I quit because I injured a young woman.
But you quit not long after you were sued.
Sure, but I was officially cleared of wrongdoing, so
And you still injured this woman of color.
yes, I did.
So you were a police officer for 9 months.
I was.
Then after you quit, you became a private security guard.
Yes.
You became an SRO.
Yes.
You became a mall cop.
Yes.
And after all of those jobs that you couldn't make it in, you decided to start your own private practice.
Well, I wouldn't say that I couldn't make it in there, but I felt that I had a different calling, which was private investigation.
So with all the experience from being a mall cop and an SRO, you decided to start your private investigation.
Well, the experience that I gained wasn't directly from being a mall cop or an school resource officer. It was from my experience in the police force.
Your 9 months of experience before you quit.
My 9 months of experience.
Let's talk a little bit about the investigation. You said you performed a partial investigation.
Yes.
And you analyzed you analyzed Kyle Kuzak and Jordan Markowitz investigation.
Yes, I did.
And you thought there was flaws in their investigation.
I did.
And you're not currently a crime scene reconstruction investigator.
I am not, but I am an expert in crime scene reconstruction.
But again, you're not employed in crime scene reconstruction.
No, I am not.
Yet you decided to critique a crime scene reconstruction investigator's work.
Considering the fact that I am an expert in it, yes.
But again, you're not employed in the field of crime scene reconstruction.
As I've said before, no, I am not.
Let's talk a little bit more about your investigation. You didn't collect any photos, did you?
No, not on the crime scene.
And that was because it was a partial investigation?
Yes.
Let's talk a little bit more about the investigation. You believe there was another suspect.
I do.
You believe that was Blair Rollins?
Yes.
And you never had an interview with Blair Rollins, did you?
No, I did not.
You never called Blair Rollins?
No, they were a potential suspect.
You never got Blair Rollins' cell phone records?
No, I did not.
And you made an attempt to talk to Blair Rollins, didn't you?
Yes, I did.
You used Google to help you find them?
Yes.
And after Google didn't help you find your only suspect, you decided to look elsewhere.
Well, Blair Rollins is not my only suspect, but they were a potential suspect, so.
And you base a lot of your investigation off of the theory that it could be Blair Rollins.
No, I would not say that.
But you base some of your investigation off of the theory that it could be Blair Rollins.
Some, sure.
But you never had an interview with Blair Rollins.
No, I did not, as previously mentioned.
And you were never able to conduct an an interview from your private practice with Blair Rollins?
As I previously mentioned, I did not have any interview with Blair Rollins.
We're going to talk a little bit about Kyle Kuzak. You know Kyle Kuzak professionally,
Yes, I do.
and you consider her egotistical,
Yes,
prideful,
sure.
and you're here today testifying, critiquing Miss Kuzak's investigation.
Well, yes, because I find flaws in it.
You find flaws in her egotistical ways.
Of course I do, but I also find flaws in her investigation.
And just to clarify, you see her as egotistical, and you're here today testifying about what you believe to be the mistakes were in her investigation?
I believe that the flaws in her investigation have nothing to do with her character.
And you're aware that she has 19 years of experience?
I am aware, yes.
And you're aware that you have no experience in the field of crime scene reconstruction?
Yes, I've said that before, yes.
Thank you. No further questions.
Mr. Nauman, any further examination, redirect?
Yes, Your Honor, briefly.
You may proceed.
Professor Van Owen, do you have any idea where Blair Rollins is?
I do not, no.
Do you even think he's in the state anymore?
No.
Thank you, Your Honor. No further questions.
Thank you. The witness is excused. We'll pause for a moment for the jurors to get caught up and prepare for the defense witness, second defense witness. Ms. Napolitano, you're performing direct examination of this witness, correct?
I am.
Thank you. And for the prosecution, who do we have on cross? So I do see someone on my screen. If I know it's not Ms. Thompson, who might you be, and what is your function here at the moment?
Hi, my name is Emma Klausner, and I'm doing the cross-examination of Taylor Perkins.
Sorry, Ms. Klausner, my memory must not be that good, or my visual memory. So where's your witness?
The defense calls Taylor Perkins to the stand.
Okay, thank you. And will the witness who is playing Taylor Perkins please identify yourself for me?
Esteban Reich, playing Taylor Perkins.
Thank you, Ms. Reich. You may proceed.
Please state your name and spell your last for the record.
Taylor Perkins, Perkins.
Do you know Mr. Becker?
Yes, I do.
Can you tell us how you know Mr. Becker?
We were best friends in high school.
Did you hang out with Mr. Becker a lot?
Sure, yeah.
When did you hang out with him?
Well, we hang out after school and we hung out at mock trial practice.
And do you know Mr. Cifuentes?
Yeah, Miss Cifuentes and we were also on the mock trial team together.
Are you and Miss Cifuentes very close?
Not at all, no.
Are Miss Cifuentes and Mr. Becker very close?
Definitely not.
And can you tell the jury how you knew Mr. Brackman?
He was our mock trial teacher.
Did Mr. Brackman and Mr. Becker talk to each other a lot?
Sure, in mock trial.
And did you hear them talk to each other a lot?
Yeah, we were all there. It was practice.
What was the usual tone of their conversations?
Angry, irritated. They were arguments.
How would these arguments usually end?
Well, they both end up pretty angry, visibly pretty angry.
Could you give us an example?
There was one time when Avery showed up to practice pretty unprepared even for Avery, and Mr. Brackman just really got angry at him for it. And so he kicked Avery off of A team, which for people who don't know mock trial is the better team. So I ended up helping Avery get back onto A team because he deserved it, you know?
So Mr. Becker was still on the team then at this point?
Yes.
Could you tell us at what point he was no longer on the team?
Yeah. Sorry. After the regional competition, Mr. Brackman got very mad at Avery for winning an award, and so Avery got mad, pulled a prank, and Mr. Brackman kicked him off the team.
Did Mr. Becker try to get back on his mock trial team?
Sure, yeah.
How did he try?
Well, he went to Mr. Brackman's office to try to get back on the team, and when that didn't work, we ended up asking other people on the mock team to help us.
When did he visit Mr. Brackman's office?
That would be March 5th, 2020.
Did you see Mr. Becker after he visited Mr. Brackman's office?
Yes, I did.
Where did you see him?
Well, we went to the Fry Shack, which is a pretty popular mock hangout after he visited Mr. Brackman.
What happened at the Fry Shack?
We hung out there, met up with some mock kids after their practice, and just, yeah, we were hanging out.
Did Mr. Becker talk to the kids there?
Yes, he did.
Including Mr. Cifuentes? Miss Cifuentes?
Yes.
How did these conversations end, would you say?
Most of the people were expressing their, condolences, I suppose, because it was unfair that Avery got kicked off, but I think that Avery was pretty angry, not in the best mindset, and Alex Cifuentes was setting him off, so he ended up kind of storming away to go to the bathroom.
Did he have his phone with him when he left?
I don't believe so, which is pretty odd for Avery.
And what did you do when he came back?
We hung out for a little while longer, and then we ended up leaving the Fry Shack, going to the mall, hanging out.
I want to talk about March 6, 2020. Did you see Mr. Becker then?
Yes, I did.
What happened when you saw him?
Well, Avery picks me up to go to school, and so that was the first time that I saw him that day. And we had wondered where his phone was because I'd been texting him and he hadn't noticed.
What did you do when you realized he didn't have his phone?
We decided to skip school. We had a free period and then just skipped the rest and went retracing our steps through the mall, the Fry Shack, to try to find the phone.
How long did you search?
Pretty much the whole school day.
Did you ever find his phone?
No, we didn't.
No further questions at this time, Your Honor.
Thank you, Ms. Napolitano. Ms. Klausner, do you care to cross-examine?
Yes, Your Honor, I do.
You may
Miss
proceed.
Perkins. Miss Perkins, you were Avery Becker's best friend.
Yeah.
You went to the same school as Avery.
Yes, I did.
You were on the mock trial team with Avery.
Yes, I was.
And you would say that your best friend was pretty skilled at mock trial.
Yeah, he was.
But not everybody, from what you observed, seemed to agree with this.
No, they thought he was skilled, but they didn't think he deserved it.
Your own coach didn't think that Avery put in enough work.
Yeah.
So much so that Mr. Brackman decided to demote Avery from the A team.
Yeah, that's correct.
And so you stepped down from the team for your friend.
Sure.
You stepped down so that Avery could take your place.
Yeah, he was always more in a mock trial than me.
And that worked. Avery was back on the team.
Yep.
And the team went to regionals where Avery won a couple awards.
Yeah.
He won the Best Attorney Award.
Mm-hmm.
And the Best Closing Argument.
Mm-hmm.
And you were really proud of your friend.
Of course.
But Mr. Brackman didn't seem to be so proud.
No, he wasn't.
He told Avery that he did not, that he seemed to think that Avery didn't put in enough work to deserve those awards, from what you observed.
Yeah, that seemed to be the tone.
And this made Avery really upset.
Yeah, understandably.
He took a permanent marker and wrote Worst Attorney Award across the hood of Mr. Brackman's Porsche.
Though he didn't know it was a permanent marker according to him at that time, then yes.
But nonetheless, it was a permanent marker.
Yeah.
And Mr. Brackman kicked Avery off the team for good at this point. But Avery didn't want to give up. He wanted to apologize.
Yeah, of course.
And so the next day, Avery went to mock trial practice trying to apologize.
Yes.
But Mr. Brackman told him to leave.
Yeah.
And so you two spent some time together.
Mhm.
And you tried to come up with ways that Avery could get back on the team.
Yeah, we did.
And so you decided it might be a good idea to text the rest of the team to try to convince Mr. Brackman.
Yes.
And you claim that Avery did text everybody on the team.
Yes.
Would you be surprised to know that Avery claims that he didn't text anyone?
Yeah, somewhat.
And so you two spent some time at a few places that night. And the next morning, you two realized that Avery's phone was missing.
Yeah.
You went the whole part of the evening and the entire morning without realizing Avery's phone was gone?
Yeah, he wasn't able to use it at home, and so after he had gone home, there was no way for him to know, really.
Even though there was a possibility Mr. Brackman could have texted him back during that time.
Mr. Brackman?
Yes. Earlier that day, Avery tried to apologize to Mr. Brackman and didn't get to.
Yeah, I'm not completely sure, but I don't know if that would be something that would have happened. We were pretty sure that Mr. Brackman was just done with Avery.
Pretty sure, but not certain.
Yeah, that's correct.
And so you spent the whole day looking for the phone.
Yes.
You looked at the Fry Shack and at the mall.
Yep.
And that took the whole day.
Mm-hmm.
Thank you, Your Honor. No further questions.
Thank you, Ms. Klausner. Ms. Napolitano, redirect.
An incredibly brief one, Your Honor. Ms. Perkins, do you understand the severity of this case?
Yes.
Would you ever lie about something this serious for Mr. Becker?
No, of course not.
No further questions, Your Honor.
Thank you. The witness is excused. We'll give the scoring jurors a moment to catch up. And then we will turn our attention to the third and final defense witness. Will counsel and the witness activate your video? I see Ms. Schumann. I see someone, Mr. Becker is here with us. And then I see Ms. Chamberlain again. Is that right? You can all speak. You can unmute. Let's get that done.
Yes.
Okay. Thank you. Thank you, Ms. Schumann. Ms. Chamberlain, can you unmute? I just want to make sure that you're active. You there?
Yes, Your Honor.
Thank you. And Mr. Becker, can I please have your real name for my file?
Daniel Yanez.
Okay. Thank you, Mr. Yanez. You are now Mr. Becker. And Ms. Schumann, you may examine the witness. Is that right?
Thank you, Your Honor. State your name and spell your last name for the record.
Avery Becker, Beckerer.
Did you know Mr. Brackman?
Yes, he was our mock trial coach.
And how many years did you do mock trial?
I did mock trial for all 4 years of high school.
Was Mr. Brackman your coach for all 4 years?
Yes.
Did you enjoy mock trial?
I enjoyed showing off. It was a lot of fun being one of the better attorneys in the room. But yeah.
And did you get along with Mr. Brackman?
Oh, no. No, we did not like each other at all.
Why did he not like you?
He didn't like me because he was jealous of my natural abilities to be a mock trial attorney.
And did this ever affect your time on mock trial?
Yes, we would basically argue every single practice about it over he's saying that I don't have the level of commitment or work ethic to mock trial that is required, and it wouldn't make sense because I did. So
Did you ever get back at Mr. Brackman?
I did draw on his Porsche, but other than that, no.
What did you draw?
I drew the words "worst attorney award" as right before that he was making fun of me, saying I didn't deserve my award for the best attorney award that happened during regionals that previous year.
And do you regret writing that on his car?
Yes, probably one of my biggest mistakes. I definitely should not have done that.
Okay. Did you ever do anything else to him or his home?
No, no,
Did you even know where he lived?
no, I did not.
All right, moving on to March 6th of 2020. Did you have your phone on March 6th?
No, I didn't.
Where were you?
Well, that morning I woke up and I realized I didn't have my phone, so I got up, went to Taylor's house, and we both decided, listen, I don't have my phone. Let's skip school, okay? Let's skip school and let's find the phone. And so we basically retraced our steps from when I had lost it, which was I believe the night before. And we went to the Fry Shack that night. We went to the mall, and so that's where we started with the mall.
Okay. And where were you the night before when you think you lost it?
Yeah, we went to Fry Shack restaurant.
And was there anyone else at the Fry Shack?
Yeah, usually the mock trial team has that spot as like a favorite place to eat, and the mock trial team was there.
And who all is on the mock trial team?
A whole lot of people, but Taylor, my best friend's on the mock trial team, and Alex Fuentes.
Who is Alex Fuentes?
Alex is a wannabe friend of mine. Alex thinks that she is my best friend. It's not true at all. That's Taylor, but they're basically just on the mock trial team with me.
And do you get along with her?
I get along better with Alex than I do with what I did with Coach. Yeah.
And who is Blair Rollins?
Blair Rollins is just some other student at CHS Colorado High School that attended with us.
Are they your friend?
I really didn't know them that much, so not really, no.
Okay. And what does Blair look like?
I don't really know the facial aspects, but I know that Blair is similar build, similar height to me.
Cool. And do Blair Rollins and Mr. Brackman know each other?
Yes, actually. Mr. Rollins, Blair's father, was in court with Mr. Brackman, and Mr. Brackman failed to accurately defend Mr. Rollins.
And what resulted from that trial?
Mr. Rollins got thrown in jail.
All right. Your Honor, at this time, I will share my screen with Exhibit 14, which I believe has previously been entered.
That's right.
Okay. Mr. Becker, do you recognize these?
No, I can't say I do.
So did you send these texts?
It says my name up there, but I did not send those texts.
Thank you. Finally, did you see Mr. Brackman on March 6th of 2020?
No.
Were you at Mr. Brackman's home on March 6th of 2020?
No, I don't even know where he lived.
And finally, did you kill Mr. Brackman?
No, absolutely not.
Thank you. No further questions, Your Honor.
Thank you, Ms. Schuman. Ms. Chamberlain, you may cross-examine.
You were really good at mock trial, correct?
Oh yeah, one of the best.
You could say you were a natural.
Yeah.
You could even say you had the judges like putty in your hands.
Oh yeah.
But not everyone appreciated this talent.
Yeah, Mr. Brackman was one of them.
He even demoted you to B team.
Yeah, he demoted me to B team, not for my abilities, but mostly for what he believed was my level of commitment in mock trial.
But your best friend Taylor quit the A team for you. She had your back.
Yes, it was selfless sacrifice.
And now let's talk a little bit about the practice after regionals. You walked in with your head held pretty high.
Yeah, I just won 2 excellent awards. I got good scores for regionals. Yeah.
And you were expecting some appreciation from your team and your coach.
Yes.
But instead, Mr. Brackman humiliated you in front of your team.
Yeah, he did.
He told you you didn't deserve these awards.
Yes, he did.
And you stormed out of practice.
Yeah, I did.
You stormed out with that permanent marker in your hand.
Yes, I did. But in my mind, I thought, because we were doing mock trial with the dry erase markers. So in my mind, I thought I had a dry erase marker in my hand.
But it did turn out to be a permanent marker.
Yes.
And you stormed out of the building.
Yes.
And there stood his Porsche.
Yep, that noxious white Porsche. Yes.
And you stormed up to that car.
Yeah.
And you wrote the words Worst Attorney Award on the hood.
Yes, I did.
All 18 letters.
Yeah.
And now let's talk a little bit about March 5th. You went to Fry Shack with your best friend Taylor, correct?
Yes, I did.
And you saw Alex Cifuentes there?
Mm-hmm.
And he made you kind of mad that night.
Yeah.
And you and Taylor ended up leaving.
Yes, we did. We straight out and left.
Now let's talk a little bit about March 6th. You couldn't find your phone that morning.
Yeah. The last place I remember having it was before the Fry Shack.
And you and Taylor skipped school to look for that phone.
Mm-hmm.
You searched aimlessly all day.
Yeah.
You went to Fry Shack.
Mm-hmm.
The mall.
Yeah.
Nowhere to be found.
No, nope.
And let's talk a little bit more about your relationship with Mr. Brackman. When he demoted you, it made you pretty angry, correct?
Yeah.
And when he kicked you off the team, it made you pretty angry.
In the instant of being kicked off the team, yeah, I was mad, and that's why I took it out on his car. But now that after the benefit of hindsight, I've kind of calmed down, and I asked for Coach Brackman's forgiveness.
And when he humiliated you in front of your team, it made you pretty angry and upset.
Yep.
Thank you, Your Honor. No further questions.
Thank you, Ms. Chamberlain. Redirect by Ms. Schuman.
No, Your Honor.
All right, for the defense, that by my book is the final witness for the defense. Does the defense rest?
Yes, Your Honor, the defense rests.
Thank you, Ms. Schuman. The scoring judges will have a moment to get caught up. And then I would ask that the prosecution closing argument be ready to go. I can't recall who's doing that for us, but I'm sure I'll find out here in a moment. If you are delivering the prosecution closing argument, will you activate your screen and unmute, please?
That would be me, Your Honor.
All right, thank you, Ms. Chamberlain. I wasn't sure. I appreciate that. We'll wait for just a moment, let the scoring jurors get caught up. All right, Ms. Chamberlain, you may proceed with closing argument for the prosecution.
Your Honor, before I start, the prosecution would like to save any remaining time for rebuttal.
You have my permission. I'll note that. You may proceed.
Get out, get in, get even. Ladies and gentlemen, today you heard the story of Mackenzie Brackman. Mackenzie Brackman was a beloved local defense attorney and coach for the Colorado High School mock trial team. Mackenzie Brackman would spend his days tirelessly working to defend people who some others might not even give a second look to. After he spent his days doing this, he would donate his free time and coach the Colorado High School mock trial team. He truly believed in these kids and saw their potential. But as you saw today, not everyone on the Colorado High School mock trial team appreciated Mr. Brackman as their coach. Avery Brackman did not appreciate Mr. Brackman as his coach. He thought that Mr. Brackman was not very good coach, and Avery thought that he was a better attorney himself. Ladies and gentlemen, today you heard the story of how Avery Becker was told to get out of mock trial and out of Mr. Brackman's life. You saw how Avery Becker got in to Mr. Brackman's house through the ring videos and the cell tower data. And finally, you saw how Avery Becker got even by trashing Mr. Brackman's house, and which resulted in his death. The prosecution called 3 witnesses today. The prosecution called Jordan Markowitz, Kyle Kuzak, and Alex Cifuentes. Jordan Markowitz and Kyle Kuzak showed us how Avery Becker got into Mr. Brackman's house through the ring videos and the cell tower data that placed Avery Becker's phone at or around Mr. Brackman's house during the time of the murder. Alex Cifuentes showed us the text messages and where Avery Becker told him he was going to get in and get even. Alex Cifuentes also told us how Avery Becker was told to get out of mock trial and out of Mr. Brackman's life. The defense also called 3 witnesses today, ladies and gentlemen. The defense called Blake Van Owen, Taylor Perkins, and finally Avery Becker. Blake Van Owen is getting paid hundreds of dollars to be here today. He's getting paid hundreds of dollars to find Avery Becker innocent. And let me remind you, he has only ever testified for the defense. Taylor Perkins is completely biased in the case today because she is Avery Becker's best friend and would do anything for him. Avery Becker is here today because he would do anything to save himself and anything to be on the mock trial team. Ladies and gentlemen, today you heard the story of how Avery Becker was told to get out of mock trial and out of Mr. Brackman's life. You were shown how Avery Becker got in to Mr. Brackman's house through the ring videos and text messages. And you were shown how Avery Becker got even by trashing Mr. Brackman's house, which resulted in his death. Thank you.
Thank you, Ms. Chamberlain. Just checking with the timekeeper, is there any time left? And if so, how much?
Yes, there's 2 minutes and 9 seconds left.
Okay, 2.09, got it. And for the defense, Ms. Schuman, are you offering the closing argument?
Yes, I am.
You may proceed.
Thank you. The prosecution is taking the easy way out. From the moment the prosecution began investigating, everything that was done incompletely. In this case, the prosecution has the burden of proof. They must prove to you beyond a reasonable doubt that Avery Becker committed this crime. But as you see, the prosecution is merely taking the easy way out and cannot prove beyond a reasonable doubt any of the crimes. Our story begins on March 6th of 2020, where Mackenzie Brackman was murdered brutally in front of his own home. Detective Markowitz responded to the scene, and at the scene, she took photos, recovered Ring camera footage, and saw nothing else out of the ordinary. This begins the story of our lazy investigation. Multiple photos from this crime scene were corrupted, and Detective Markowitz claims that she never was able to recover these photos as they were lost in the camera. But Kyle Kuzak claims to have used these in forming her expert opinion and that they were a vital part of her investigation. And the Ring camera footage was not labeled with a date or a time, and as well could not identify any specific person within the footage. Both of these things provide reasonable doubt. From here, the detective continued to take the easy way out. Detective Markowitz only ever spoke to one student, Alexa Fuentes. And this student only ever provided one lead, Avery Becker. The detective never even considered any other leads, including any number of angry former clients, including Jonathan Rollins and his son, Blair Rollins. Blair Rollins is the biggest show of this incomplete case. Blair Rollins, the same build and size as the person in this footage, has more motive than ever. Mr. Brackman defended his father, Jonathan Rollins, in a trial. And the result of that trial was Jonathan Rollins being thrown into jail for life. But Detective Markowitz decided to take the easy way out once again. She ignored this lead and any other, and instead used screenshots that Alexa Fuentes took from a phone that she never was in possession of to show intent for this crime. These screenshots were from Alexa Fuentes, who could have easily tampered with them. And Detective Markowitz chose to receive call detail records for Avery Becker's phone, but she only ever received the records for Avery Becker's phone at the time of the murder, not before nor after. She did not even receive records for the night before when Avery Becker claims to have lost his phone. She took the easy way out and never looked at the big picture. This provides reasonable doubt. Furthermore, Markowitz never looked at the same cell. She never looked at any other cell tower data, including including Taylor Perkins' phone or Blair Rollins' phone. And she knew that the same cell tower that they had tracked Avery Becker's phone from covered Blair Rollins' home. But once again, the detective decided to ignore this as it is easier to take the easy way out. If they had completed a thorough investigation, the prosecution would have known that Avery Becker was not at Mr. Brackman's home. She would have found that Taylor Perkins and Avery Becker were both at the mall. Blake Van Owen, wanting to do a full investigation, found that Taylor Perkins' phone was at the mall as he claimed. And Blake Van Owen found that Mr. Perkins and Mr. Becker were not in class on the day of March 6th of 2020. But with a thorough investigation, she also would have known that Blair Rollins was absent on March 6th of 2020. However, it was easier to ignore this evidence as it makes the prosecution work hard. Instead, they blame Avery Becker and take the easy route. This evidence provides way more than a reasonable doubt that Avery Becker was not even at the crime scene on March 6th of 2020, much less committed the crime. The prosecution therefore failed to prove that Avery Becker committed criminal mischief, and therefore failed to prove every single one of their charges. Members of the jury, Avery Becker is the easy way out. But as with most things in life, the easy way is not the right way. Avery Becker did not commit this crime, as easy as it may be to say that he did. Instead, I urge you to not take the easy way out and find Avery Becker not guilty. Thank you.
Thank you, Ms. Schuman. As she has reserved 2 minutes, 9 seconds from her time allotment, I will allow Ms. Chamberlain that much time for rebuttal.
Ladies and gentlemen, today you heard the story of how Avery would always take the easy way out. Avery Becker would never put enough effort into mock trial. And yeah, of course, this made Mr. Brackman angry. Ladies and gentlemen, today the defense claims that the prosecution is taking the easy way out. But our 2 expert witnesses did full investigations, whereas the defense's one expert witness did a partial investigation, as you heard her admit today. Ladies and gentlemen, every single one of the defense's expert witnesses and witnesses today have a bias in this case. Blake Van Owen is getting paid hundreds of dollars to be here today, and she has only ever testified for defense. Taylor Perkins is Avery Becker's best friend and would do anything for her. And Avery Becker is here because he would do anything to save himself and to be on mock trial team. Ladies and gentlemen, we have shown you today how Avery Becker was told to get out of mock trial and out of Mr. Brackman's life. We have shown you how Avery Becker got in to Mr. Brackman's house, and we have shown you how Avery Becker got even by trashing his house and finally killing him. Ladies and gentlemen, we ask you to find Avery Becker guilty on all accounts. Thank you.
Thank you, Ms. Chamberlain. The case now stands submitted. I want to pause for just a moment and allow the scoring jurors to complete their scoring sheets. And scoring jurors, when you're done with that, activate your screens and unmute so that we have an opportunity to talk with these students. But I guess my first reaction is that this was a really good trial, and I'm going to activate my little hand clap for all of you because I think you did a really good job. So, and I'm certain everyone in the room feels that way. So standing by for just a moment, we'll get the scoring jurors on the screen and unmuted. And I want to give everyone just a few minutes. I'm talking a minute or so to comment, and then we'll circle back to me. Is that okay, Mr. Aro?
It is. I want to throw out 2 closing items right before you begin that. First is obviously to thank all the scorers and you, Judge McCarter, for doing this, to congratulate all of the students on their efforts today, but also to remind the scorers, I know you've heard this multiple times, to please hit the submit button at the bottom of the screen. We will not receive the scores unless you do so. And also to let the students know that your next pairings will be posted on the platform as soon as we can complete the scoring. But as a reminder, in order to see that, the platform has to refresh. So you have to fully exit the platform and then log back in once they've been posted. So anytime you want to check to see if they've been posted up, you'll need to fully exit and then log back in. Thank you.
All right, thank you, Mr.